All right, now that we have the disclosures out of the way, I want to welcome you. Thank you for joining me today. My name is Adam Ouellette. I'm an attorney and also a licensed real estate law instructor. So I can teach real estate school and have been able to do so for about the past 10 years. And I've also had a real estate license for almost 25 years now. I got it when I was 19, and I actually sold real estate when I was in college and some when I was in law school, but learned the business back before computers were really out there, and did it in a way where I know what it takes to get a closing done. I know how much you guys go through as agents to get to the contract. And one of the reasons I want to do this webcast on escrow, it's pretty boring, but the fact is escrow is one of the most important things that you are handling outside of drafting the offer and the contract forms. Escrow is a big thing in terms of licensee complaints and where there's big issues in losing your license. And so today is going to be a very quick video, but I bet a lot of you are violating the license law by not doing some things, and if you're not doing these things, well, you better start doing them, because as in the webinar I just did a couple days ago on protecting your license, I discussed the fact that today in August of 2014, the DBPR is asking their investigators to do a lot more office checks. And so if they pop in your office for no reason for a check, the first thing they're going to look at is escrow and whether you're following the rules and regulations that are required of you as an agent. And if you think you don't have a lot of requirements because the title company or an attorney holds escrow for your office, then you're mistaken. So please pay attention to this and see if you're following it or not, because this is pretty important stuff here. So let's go back to real estate school. Here's the law. You're probably not going to look it up. I wanted to give it because there are some people who like to read the statutes and administrative code. But a deposit is earnest money. It's a good faith deposit on the amount due in a transaction. It could be check, cash, money order, or wire transfer. But basically, a deposit is made because it puts the buyer on an obligation if they don't fulfill the obligations of the contract to lose some money. And basically it's earnest money, good faith. Timing. You must turn your deposit into your broker by the end of the next business day after receipt. So if you receive the check on a Friday, the next business day would be Monday, unless Monday's a holiday. But the best practice is to get that check over to your broker the very same day. And because I'll tell you why. A lot of people forget. They forget they have the check. They are waiting for whatever to happen under the offer contract, blah, blah, blah. And also, make sure under the contract that if the check is supposed to be in the bank when the offer is presented, then it's there, because you could put your customer in breach if you didn't do that right away. So best practice, get that check over to your broker as soon as possible, but the law requires you to have it there by the end of the next business day after you receive it. Once it's turned into the broker, even if it's to a receptionist, then it's the broker's responsibility to deal with these funds. So what are your obligations when filling out the contract form under statutory law and administrative code? Well, if your brokerage is going to be the escrow agent, then you need to add the same information as if the title company or a real estate attorney is going to hold escrow, or an attorney, doesn't matter if they're a real estate attorney, they can hold escrow as long as they have an account to do so, a trust account. But regardless, you need to provide the legal business name of the company or attorney holding escrow, their address, and their phone numbers. And it's best practice to include an email address for the escrow agent as well. It makes it easier to have the listing agent, even the buyer, contact them, or even the seller. And the FAR bar has this as a field, so you can add the email address to it. So if you have that information, put it in. Just makes it easier for anybody who wants to contact the escrow agent to do so. So how do you comply and make sure that you are doing whatever you have to do under the law if there's a title company or attorney holding escrow? First, what's your office's procedure? Do you bring the check to the escrow agent yourself? Does the broker send it via FedEx or mail? The timing really doesn't change for getting it to the escrow agent. You have a responsibility to turn it over to your broker, and then the broker has to get it to the escrow agent under the law is just a couple days, 3 days. But the fact is, the best practice is get it to your broker right away, and the broker should be getting it to the escrow agent tout suite, which is immediately, as soon as possible. And the offices we deal with, we actually give them FedEx slips so that they can just drop it in FedEx any day that they get an escrow deposit, so that we get it the next day. We want to make sure that money gets in the bank, because ultimately everybody has a vested interest in that money being deposited, and make sure the check clears and is collected funds. So second, what happens when the check is delivered? If you deliver it personally, then I would get a receipt of delivery for your file. And all that means is have the escrow agent, even if it's a receptionist, sign something saying that you delivered X number of dollar deposit, check number 1234, whatever it is, to the escrow agent, and it was delivered on this day at this time, and have someone from the escrow agent sign it. And then once they have it, it's their responsibility to deposit it. But thirdly, your obligations don't end there. Under the law, and I bet a lot of people out here watching this are not doing this, so this is why I'm doing this video, you must request in writing, and it can be an email, but make sure you get confirmation that they got the email, and I would put in the email, please confirm receipt of this. And if they don't confirm receipt of the email, then I think you need to send them a letter and or a fax. Protect yourself, because this is important. So you must request in writing within 10 business days of the deposit being due a written verification of the deposit from the title company or attorney escrow agent. And this is required for every single deposit to be made under that contract. So if you have an additional deposit that needs to be made or is going to be made after the inspection period or whatever it might be, then you have to do this for each deposit. And so why I tell people from the get-go, just get one deposit if you can help it, then you don't have to do this stuff twice. And so 10 business days, let's go through this again, 10 business days from the deposit being due. So the initial deposit, if you've got something that's coming together, you need to get that check to the escrow agent and then put something in writing to them requesting a written verification of the deposit being made from the escrow agent. And then no later than 10 business days after you request that, and you know, it depends on what your brokerage, if you're doing it or the broker's doing it, but somebody needs to do it. So you need to check this and make sure that it is getting done, because ultimately, you know, you're responsible for doing this. Your brokerage is responsible overall, but it's your license too. And so if your broker's not doing it, you need to make sure you do it. But no later than 10 business days after the request is made, then the brokerage needs to provide the written verification of the escrow to the listing agent or broker, listing agent broker, one or the other or both. So you have to have written verification within that 10 days. And if you don't have it, what if they don't provide it? That's the next line there. Then the fact that no verification has been provided by the escrow agent must be disclosed in writing to the listing agent and listing broker. So you send something to the listing agent, it's to the listing broker as well. But if you don't get something back within that time frame, within the 10 business days after the request is made, then you need to let the other side know that they haven't provided anything. And so the next question is, what if the seller's attorney or title company is the escrow agent? Well, then you are under no requirement to request this, because ultimately if the seller's attorney or title company is involved, then that's their interest in getting the deposit, and you don't have to request anything from them. I mean, you may want to make sure that they put the money in the bank just because it protects you and your commission as well, but the requirement is waived to get this written verification from them. So that's it on this. Did you get some good content? If you want these videos sent to you as they come out, you can sign up, what I call Real Property University, realpropertyu.com. Sign up there. You'll get these videos as they come out. I mean, literally have ideas for 100 different videos on real estate law and business and marketing and all kinds of stuff that I'm working on, and also my partner Candace as well. So sign up there. I appreciate you for the fact that you joined me today, because I think lots and lots and lots of agents and brokerages are not following this law. Most people think that, okay, well, I'm not holding escrow, I don't have to do much. Well, it's not the case. So Give us a try on your next closing. Here's my information. If you have any questions, feel free to email me at adam@broward-law.com. There'll be a link here on the video to do that. But thanks for joining me. I appreciate you being here and learning. Have a great day and a great week. Bye-bye.